So for our second panel this afternoon, appearing as an individual, but certainly an individual who knows a lot about the subject matter covered by Bill C23, Jean-Pierre Kingsley, who's the former Chief Electoral Officer of Canada. Welcome, sir. Good to have you here, and I'll give the floor to you for an opening statement.
Thank you, Mr. Chairman. Honorable Sénateur.
Honorable Senators, I want to thank you for inviting me to appear here before you with respect to Bill C23, a very long and complicated bill. Senator Joyal expressed his hope that I would reappear here when a few months ago, a few years ago, when I left the position in 2007. I can tell you that I'm only going to be speaking for about 3 minutes' time. I'm not going to go over the deposition that I made at the Standing Committee on Procedure in the other place. The clerk and I agreed that it would suffice for me, it would be sufficient rather for me to go over a few main points.
Consider positive elements in the bill concerning robocalls, the registration of service providers and the retention of records, the significant increase in fines to $50,000 and $100,000 depending upon the infraction, the graduated and significant reduction in the reimbursement of campaign expenditures in cases of overspending of the limit, the fourth day of advance polls. Quebec election has just demonstrated the popularity of that. The reformed schemes for loans and unpaid claims, the legalization of the Advisory Committee of Political Parties, and the requirement for statutory interpretations and advanced rulings by the Chief Electoral Officer. Those were the positive elements. I
feel that there are two relatively neutral changes in the bill: the transfer of the commissioner into the office of the public prosecutor, the right to speak publicly with respect to an inquiry, and the burden of the obligation with respect to a person who is conducting an inquiry. The 54% ceiling being lifted, and the 25% also for contributions. These are neutral. But there are other changes that concern me and should be considered. Taking away the party expenditures ceiling, enshrining in the Act the right for the CEO to have direct documentation and communicate directly with all parties. And I also refer to the constraint of parties if this comes before the courts.
Were broached. The retention of the vouching process with the addition of obtaining written oaths, something that the bill does not foresee at this time. And the repeal of Section 18 of the bill to restore the Chief Electoral Officer's right to speak to Canadians and to reach out to disadvantaged electors, including youth, minority groups, and new Canadians. The confidence of Canadians in their electoral system must be maintained once this bill is passed. Hence, its very legitimacy. Thank you.
Thank you, sir. We appreciate the brevity of your opening statement because members are anxious to ask questions, and we'll begin those questions with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and welcome to the witness here today, certainly an expert on the Elections Act. And I would, first of all, direct his attention and seek his expansion of a statement that he's given to this committee. The statement says as follows. Firstly, there is Bill C23's proposed abolition of the legal provision whereby one elector can prove his or her identity through vouching by another elector. This will directly affect the constitutional right to vote of a significant number of Canadians, comma, without justification, period. Now, Mr. Kingsley, The without justification is important because, as Section 1 of the Canadian Charter of Rights and Freedoms says, you get to a point where a court says, well, okay, this violates the Charter, but is it saved by Section 1? Is it justified in a free and democratic society? You've said here it is not, that it is absolutely unconstitutional because it will deny a right to vote for a significant number of Canadians. Could you identify the numbers of Canadians involved and verify that you are concluding that it will not be saved by Section 1 of the Charter?
Well, when I made the comment, obviously, I was keeping in mind the report that was produced, which identified 120,000 approximate number persons who were vouched for during the last general election. And the report that was produced, which reported so many administrative problems, irregularities, where a lot of documentation was not prepared. And I recommended two things in my remarks to handle this matter. The first one was get people to do their job. The deputy returning officers, the clerks, the people who receive people to be vouched. You see, one must understand what the process is here. I'm not talking about how you vouch. There's people in line, 20 people in line. They're all waiting to vote. One of them shows up with somebody else and says, I don't have my ID, but my brother's here, he'll vouch for me. Where are you? What's your name? Check the name, the names is there, the names are there, the addresses are there. Okay, you vote. I haven't got time to fill out forms. Now, in 2006, you'll forgive me for doing this, but I told the two committees, you needed additional staff for this. I recommended one additional person because the bingo cards were being introduced at the same time. All of that burden was put on the deputy returning officer and the clerk, no additional staff, same number of electors, all lined up. So therefore, we created a situation whereby these people have to move. The line's got to move. Canadians don't like to wait in line for a long time. I got phone calls if they waited more than half an hour. They'd call me up and be very upset. What kind of a system do you run? I didn't want to send them to vote in the States where it's 5 hours. So, I said, maybe we should fix the problem here. So the first solution is get the people to do their job. Now the Chief Electoral Officer, through this bill, will have the opportunity to appoint additional staff. The second one is the bill proposes in two cases where there's vouching now, where there's other forms of oath-taking, this used to be verbal, but there was a document prepared by the electoral authorities. The bill proposes that the oaths now be in writing as well, not just the documentation concerning it, signed by the person taking the oath. Well, there are two oaths that are taken when there's vouching. The person doing the vouching and the person being vouched for. The two of them should sign oaths, and that will solve the problem in one fell swoop. Those two measures together, you have yourself a solution to the vouching problem. You see, and I want to add one further thing, and I know I'm taking up your time. People forget that we have a system that was based on trust of electors until 2006. Then we changed the whole mentality and said, this is no longer good through the Accountability Act. We said, you need proof of address from now on, and not only that, you're going to need proof of identity, you're going to need proof of address. We want both. But we didn't set up, there's no federal authority that produces a document that's readily available with those two pieces of data on it. It's a form of inequity, and I relate that in my remarks as well.
So you're saying that the only piece of documentation would be a driver's license, but there's no federal issued piece of ID that contains a picture of somebody with their current address on it that you can rely on. In other words, you're saying that the vouching, as you probably are aware, in some court proceedings referenced in the previous hearing, Henry versus the Chief Electoral Officer of Canada. You're aware of that decision?
The BC court.
Yes, and the government of Canada based its logic on and said that the Elections Act was a legal document and requiring people to produce identification because the government of Canada said, we have the fail-safe of vouching. That was their position. Now, you have said that doing away with vouching will take away a significant number of Canadians' right to vote. So, are you in agreement that the next court proceeding on, if this passes as such, that it is entirely likely that a superior court in this country will strike down this provision in the Elections Act that we would be instituting if this is approved?
It's difficult for me to pass a judgment on what a court will do, to be honest with you. And frankly, any question which is preceded by if, I will be very careful about. I want the whole committee to know that. Okay. I don't know how a court would decide on a matter like this. What I do know is that a court would have to take into account there are Canadians who walk around without pieces of ID and address, especially pieces of proof of address. There are Canadians in rural Canada, in remote Canada, who live their lives as Canadians without all this paraphernalia that fattens my wallet.